You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. And our guest today is Brian Ward, returning, I think, for either his third or fourth episode.
Might be fourth.
You know, if you go five, we're going to get you the jacket.
I got to get the jacket.
Yeah. Be our first Five Timers Club.
I would be so honored. It's like coming home, Kenny.
We could talk more about the coming home for another day.
Yeah.
For another day. Well, listen, welcome back. We're going to be talking about rebuttal. Before we do that, for the folks who this might be the first time they've listened to one of our episodes together, just share with the audience a little bit about your practice.
Thanks. I'm a lawyer at Trial Lawyers for Justice. We're a national trial firm, with Nick Rowley. Also a primary instructor at Trial by Human, where I met you, Kenny Berger. We try cases nationally. We take on big corporations, and we enjoy each other's company doing it. So you and I had a nice go at a resort down in South Carolina that was treating people really poorly, and to get results like that meaningfully change corporate behavior is really great. It's been really fun to see Nick's Starbucks verdict, $50 million for a Starbucks burn, kind of whipsawed around the world in 24 hours in terms of the media coverage. And that's the kind of stuff that we love to see, taking a case that most people turn down, which is, another McDonald's hot coffee case that everybody kind of hates, and then turning it into, this incredible cause where, I started seeing people that were not in this industry, that were not, affiliated with this, posting on Instagram like 50 million wasn't enough, so it's just fun to be able to practice in an area where you can take such a different public perception and then flip it. So now people are pissed off about burn injury cases and think that it really has value. So it's just fun to be able to hang out with people like you and Nick and do cases that make that kind of change. So that's what we're into.
Super fun. Yeah. And one of the things that we've seen in some of the work we've been doing recently on the legislative battle side is, Republican, Democrat, independent, or otherwise, for a lot of people, wrong is wrong and right is right. And one thing people hate, just hate, is the idea of their rights being taken away by someone who has no right to do so, to be harmed by some mega corporation or just a jerk individual, and that person kind of shrugs, or the corporation kind of shrugs, and nothing happens without typically lawyers. Corporations turn around and say, the lawyers are just about the money. It's like, no, man, every decision you've made for decades is just about the money, and now your dumbass has to give some of it back.
Well, if you're going to say that we're all about the money, it's just because we're speaking their language. So we're here to talk about rebuttal today, but I want to say you only get to the end if you get to the beginning. And shout out to Kenny Berger for the work that he's been doing in South Carolina, fighting some tort reform. And I say fighting because it is a fight, and it is an important work, but it's also education. So Kenny's really been a model in terms of testifying in front of his state legislatures and making sure that they understand the impact of some of the laws that have been proposed and funded and shoved down their throat by the insurance industry. So, we're going to talk about how you wrap these things up, but, kudos to you, Kenny, for all the work that you've been doing, making sure we have a stage to stand on in the first place.
Thanks, man. Yeah, it's been a great group of, it's kind of been like band of brothers, and sisters, all locking arms and just fighting a good fight against multinational, global interests that want to take people's rights and money and line their own pockets with it. So appreciate that. So, all right. So rebuttal. Tell us, you have done a tremendous job, and again, have been recognized for some of your work when it comes to rebuttal. But with that, the floor is yours. Let's run with it.
Yeah, rebuttal is probably my favorite phase of trial. It's up there with voir dire, the very beginning and the very end. To be able to have the first word with the jury, I feel is really incredible. It's a humbling experience. It's an honor. And to be able to have the last word with the jury is just as much, if not more, of an honor. And that's usually the first and the last thing that I tell them, is that I'm humbled and honored that I get to be the first and the last one to speak to them. And when you say it out loud, you realize that's a heavy, heavy burden. You're really putting a lot of weight onto the person that sits down right before the jury walks into that jury room to make their decisions. I fell in love with rebuttal in law school because I was part of the trial advocacy program at Loyola, with my partner Aaron Powers, with Courtney Rowley, just a really wonderful breeding ground for attorneys. And, I would always fight to get rebuttal because I just thought it was so fun. It was an area of trial where I just thought you really can bring the most creativity to it. Whatever skills I have in the courtroom, one of the best skills that I've identified that I have is I'm quick. Um, I'm other things too, but I think first and foremost, I'm quick. So I see an argument coming and I see its rebuttal fast. I have the ability to flip a defense argument on its head and weaponize it against the defense really quickly. And that's why I love rebuttals, because you don't have any time. That's a quick, that's a quick skill. You've got whatever thought process you can have during the defense closing. Maybe you get a 5-minute break, but you better be ready to speak spontaneously about something that you had not planned, and to do it in a way that is compelling, number one. Number two, the additional challenge is, how do you keep that creativity bound within a structure so that you actually know what you're doing up there and you know where you're going, and you don't just end up, kind of fizzling out and, flipping your last page of notes and being like, the end, you know? So there's got to be a bit more to it than just the quick-witted nature of it.
Yeah. So melding together the quick-witted nature of it and a structure. As you're going through a case, uh, are you structuring portions of your rebuttal? Do you have, in essence, kind of a, not necessarily an outline, but almost an outline of the outline that you're going to fit pieces into throughout the trial, or while the defense is giving their close?
Certainly, and in different ways and at different times. So I like to think of trial practice as jazz, and that's no surprise because I'm a big jazz fan. I really enjoy the genre, and people that come from the military see trial as war, so you bring your context to it. But I like jazz. The greatest and maybe only purely American art form, is based essentially on democracy. Let's share the creation of this jazz tune. So I like to think of jazz as improvisation within a well-defined structure. So in a jazz tune, we know when your solo is coming, and we know how many bars you got to play your solo. What you're going to play in your solo is going to be a surprise to mostly everybody, and it might be something that happens through eye contact or listening, or through collaboration. And that's how I feel about all of trial preparation and presentation, and the most so about rebuttal. So, I think that from a basic kind of architecture standpoint, you have to have a structure for your rebuttal, and you should be thinking about it probably, shortly after case sign up. As I start to think about what is this case about, right? We do the nuts and bolts. We've got our discovery plan. We know who we're going to depose, but then we start thinking, what's the case actually about? What's maybe the emotional core of the case? We do so much work at that at Trial by Human. And it's kind of like, well, what's the point of that? You know what I mean? I got these depositions I got to take. I got requests for productions I got to go through. What's the point of finding the emotional core? And the point is, because you have to arrive somewhere, and you're going to arrive there in rebuttal. So I like to know what the emotional core is, about the case early on. And, you and I spend a bunch of hours on the road, going out to meet clients and talking about that emotional core and having it evolve over time. And it helps animate all of the other things that you do in your case. But I think when it comes to rebuttal, the most important thing to remember is have a damn plan. The first thing is you have to have a plan. And I think that if you've got a plan for how you're going to get in, and for a plan for how you're going to get out, you're going to be really safe. So let's back up and talk about, I kind of start with, there's two fundamental approaches to rebuttal. And in each case, I'm going to choose which one I think is right for the case.
And Brian, I love
So,
you talk
yeah.
about kind of having, a beginning, and an end, start and a finish. I can't remember who it was. One of these authors was talking about like, hey, stories, you come up with your beginning, you come up with your ending, and then in between, you'll figure that out.
Yeah, you'll figure it out. It's a journey. You'll figure it out as you go. So the question is, are you doing a bigger journey or a tighter journey for rebuttal? And for me, one thing I started doing a few years ago was I rejected the notion that rebuttal should only be about the new clever thing, maybe that you didn't anticipate in the closing. And I kind of thought, well, what do these words mean, right? What is my closing supposed to be? What is my rebuttal supposed to be? What is the purpose of the defense closing coming in between those two? And it occurred to me that you don't need to have every argument laid out in your initial closing argument. You don't have to do that. If you look at the jury instructions and the way the case moves along, it's the plaintiff that has the burden of proof to make a prima facie case. And we put on our witnesses and we put on our evidence, and then we rest our case. And if we survive a directed verdict, that means there's enough evidence there to support the prima facie case. So if that's the process with the judge, maybe that process makes sense with the jury too. So sometimes what I'll do is I'll stand up and say, I'm going to talk about our case. And that's it. I'm going to show you what we proved, how we proved it, and why we think that supports the verdict. Because we have the burden, and I want to show you how we met the burden. And then I'm going to let the defense get up and say whatever they're going to say about their case and what they think they proved to you. And I'm not going to prejudge what they're going to say. I'm not going to try to rip the rug out from underneath them. I'm going to let them have as fair a crack at making their arguments to you as I have right now. So I'm not going to talk about their evidence. And that really freed me up in a lot of ways. And I think it's unconventional. It's certainly scary because it's not what most people do. But there's something really pure about that, which is, you don't have to display any of the fear that sometimes surrounds confronting a defense argument, at least not in that initial closing phase. And then you let the defense get up, and then your rebuttal ends up being pretty robust. Instead of it being a 7-minute kind of call to arms, maybe it's a 30-minute utter dismantling of the frivolous defenses and misleading evidence. And boy, they don't really have a chance to come back from that, right? And I think some people have said, oh, that feels sneaky, or that feels like sandbagging. No, it's not. It's simply responding to the arguments that they chose to make in the time where the court set forth for me to, quote, rebut those arguments that the defense made. So I think fundamentally you have to choose. Are you going to deal with the defense's case in your initial closing, or are you going to try to do it all in rebuttal? I think there's pros and cons to each approach, but in terms of setting up the structure, fundamentally that's where I begin, is choosing between those two approaches.
Brian, for folks who are listening, are you talking with the judge in advance to know how much time you're going to have for closing, how much time you're going to have for rebuttal?
Yeah. And, look, in California state court, I get all the time I need. As long as I'm compelling, no one's going to cut me off. In California federal court, I'm about to start trial in 2 weeks, and I've got 8 hours. And in that 8 hours, I must open, I must direct all of my witnesses, I must cross all of their witnesses, I must close, and I must rebut. And that is a challenge, So that's going to be an entirely new approach to how do I take whatever time I have left on the clock, because I'm on a countdown in federal court, and then how am I going to structure that? I don't know the answer to that yet, Kenny. I probably won't know the answer to that until they tell me how much time I've got left. But you need to be
Quick.
cognizant, for sure.
I wouldn't want to play in speed chess.
As terrifying as it is, I've been looking forward to a challenge like this for a long time. Our California trials tend to bloat. We really have engaged in a battle of the experts, where it's not uncommon to have 10 experts on each side. And those trials go weeks, and I don't think they need to for the jury to get it. So I've been trying to do what we call an expedited jury trial for years, which you can do in a few days. No defense will agree to do it once they see how eager I am to try it. So here we've got a federal judge that just handed it to me on a platter. So I'm excited for the challenge.
Yeah, I think it suits you, man. I think it's going to go great.
I'll take that.
I'm confident. I'll bet the over.
Yeah.
Okay, so kind of figuring out one of two roads you're going to go down, and we talked about the more robust, broader, kind of longer road. We speak a little bit about what I'll call the more traditional or conventional narrow path when it comes to rebuttal and what you're wanting to
Yeah.
do.
Again, this is, you have to have a plan, but you have to stay loose. So your rebuttal should be set up in some way, right? And there's a number of ways you can do this. And maybe one of the best ways you can do this is through case framing. And if you want to learn more about that, there's a really great podcast called Best Practices with Kenny Berger that has a whole episode on case framing that really helped me out a lot. It was a really transformational episode for me. Which is to
For
say,
those
if
who
you,
want to go back and listen to it, it's the first episode we did with a guy named Chris Hamilton out in
yeah,
Dallas, on case
Chris,
framing and big verdicts.
Chris
And
was great.
yeah,
And you should listen to the podcast instead of having me summarize it in 10 seconds. But if you frame the case right, your rebuttal kind of opens itself, which is, this is a case about whether or not a person with a history of mental illness has value when they're physically damaged. It's just kind of an example. And if you frame it around that, knowing the defense is going to harp on, well, he was so damaged before, and look at all this trauma, and look at all this mental illness, and the implication is that this is a person with less value than you or I, or quote, normal people. And if you frame it that way, you pretty much know how you're going to start your rebuttal, which is, folks, I told you so. I kind of told you that they were going to make this a case about whether or not a person with trauma and mental illness is inherently worth less. And there they went and just went ahead and did it right in front of your eyes. So now you know what this case is about and what they're hoping that you're going to do. So that's one great way, is to set up your rebuttal, is to have your case framed from the very beginning, knowing that the defense is usually pretty rigid in terms of how they present their case and how they tip their hand. Another way to set up the beginning of your rebuttal is to leave a series of questions that you dare the defense to answer at the end of your initial closing. You should have a pretty high level of confidence, and they're not going to have anything good to say about those questions because you've been through discovery and trial at this point. So that's another great way to open up your rebuttal in a way that's really comfortable. It's taking no risks. It's well planned. It keeps you on the higher ground, just like case framing. So those are two ways, I think, to get in to the rebuttal.
we give an example of kind of a question that you put out there in your closing for the defense to answer in their close, then you can come back to in rebuttal.
Yeah, just take this kind of fictional person with, trauma and a history of mental illness. Maybe I would say, and he's going to stand up now and listen whether he answers, why did they spend so much time talking about my client's past trauma if it wasn't to make you think he was worthless? I'll be listening. You should listen to, because I can't figure it out why they would do that for some kind of proper purpose. It seems to me that it was a dirty trick, but let's listen. Let's let them speak for themselves. And then let's come back and talk about what they said. So that's kind of just one example of a kind of a question that you could leave. On Nick's Starbucks trial, you could say, if you could have seated those 2 cups properly in the carrier, why couldn't you have done the same for the third? Just tell me why. If there's any good reason, I'm going to be sitting back and listening. So that's kind of some of the examples I would use.
Yeah, and I was thinking, and I'm not sure if you've done this or if you can do it in California, but kind of the classic, hey, we've shared with you all the basis of why, the right verdict for the right reasons is X, or between X and Y. And what are they going to say? Are they going to say anything? I can't imagine they're going to agree with us. They haven't agreed with us on anything so far. So let's listen closely to what they think the value is of everything the evidence has shown in terms of what's been taken from our client and what they're left with.
I think there's another way to get into your rebuttal too, and that's to choose a rhetorical device. And I'm a big fan of this too, and some of my favorite rebuttals have been framed around a rhetorical device. So what the heck do I mean when I say that? There's one that I started using in law school in competitions that I still use to this day. And it goes a little something like this. You stand up and say, at the twilight of World War II, President Truman had to make maybe the most consequential decision that a leader in the world has ever had to make in terms of how to end that war. And the pressure that he was under is literally unimaginable if you've never had your hand on the button, and none of us ever have. And as he sat at that desk contemplating that decision, he had a plaque on his desk that said, "The buck stops here." And when you think about him in that context, you really understand what accountability means. Because he knew that if he made that decision, he was going to be killing hundreds of thousands of innocent people for the greater good. And he accepted that. And he, in fact, advertised that level of accountability throughout his entire administration. Show me a defendant that's made it to rebuttal that has come anywhere close to honoring that kind of integrity and personal accountability. So, that can be delivered pretty heavy because that's pretty serious. It's a pretty outrageous moment in history where somebody had to accept accountability and needed fortitude and the strength to be criticized for his integrity. um, as it's evolved, it's become a little bit more jokey, just so there's some levity in the air. So, part of what Jacob Norman and I did in our case against Chevron a few years ago was we had the sign, the little plaque, "The buck stops here," on a slide, and it says, "But actually for this defendant," and then we manipulated it into this really, really long, absurd plaque that said, "The buck stops anywhere but here." And it was true. That was consistent with their defense. So that's just one example of a rhetorical device that you can use to enter. We've talked about my other favorite rhetorical device, which is the crazy goat, which is if once the
Oh,
defense just throws up every damn thing under the sun, you go, let me get this straight, folks. Let's just machine gun these denials and deflections and insane things. It's like, now that we've got that out of the way, let's talk about the evidence actually showed.
yeah. And once you
So,
start thinking about things in that crazy goat context, you start being like, the entire the entire defense is the crazy goat defense. It's as if like they went to the DRI. They're like, all right, guys, there's something the plaintiff's bar is not onto. Let me teach you about a crazy goat.
right. So, and honestly, about 7 out of 10 times they're going to do it. I mean, look, Nick's Starbuck case with an absolutely mangled and burned penis, and they were like, "His penis. The reason his penis doesn't work is not this terrible injury, this boiling water that we literally threw on his lap. It's the fact that he's got diabetes. He'd be fine if it wasn't the diabetes." And it's just like, guys, like that's crazy. That's crazy. You know. And you know what? He'd be having all these exact same problems. If we hadn't boiled his penis, he'd be having all the same problems that he's having today just because of his diabetes.
It's funny.
And that's
If they would have blinded the guy, they were like, we didn't blind him. Diabetes causes blindness.
it's obviously the diabetes. It's always the diabetes, isn't it?
I'd say another rhetorical I like a lot is, if they won't agree with you on stuff, you kind of flip into like their argument just to highlight the absurdity. Um, and we were doing this all the way back in trial lab in law school. A friend of mine called it the pinky toe on the shotgun defense. If I've seen it once, I've seen it 1,000 times. Just kind of pointing out just how absurd kind of what the other side was saying in this trial ed class we had. But it's something as simple as if they won't agree with you that something is dangerous. It's like, well, all right, let me ask it a different way. Um, and heck, maybe they can answer this question. In fact, listen real close to if they do. Is it a good idea? Is it safe? If they won't say it's dangerous, is it safe to serve somebody 10 drinks in 52 minutes and then send them out on the roadway with everyone's family? I mean, if they can answer that,
Right. Yeah.
more power to them, but just listen real close.
And I like that. I like getting out of the defense's way until rebuttal. And again, it's, people say it's sandbagging, but they dig their own hole. I'm just the one shining a flashlight in it, being like, look how full of crap it is. But you gain a lot of credibility that way, which is like, I'm gonna let them speak for themselves, but look, here are the issues I think you need to be paying attention to, and that's all I'm gonna let you know. Like, listen carefully, ask yourself if it makes sense. Like I said, I'm gonna come back up and we'll talk about what they said afterwards because I've got the burden, and that's my job. That's what I have to do. So listen close. I'll see you in a few minutes. And they know that I mean to be skeptical of the defense, but I haven't asked them to agree with me on anything yet. I haven't told them this is BS, right? And you should reject it. You haven't heard it yet, but trust me, right? So we don't have that confirmation bias that's interfering with the relationship. I just say, let's just listen for these topics. They know damn well I'm skeptical of the defense. And they're like, oh, you tell me to listen, I'll listen. They're going to listen. They're going to form their own conclusions. If I've
And the
done my
fun
job
part too is if that's what they're listening for, it's like they're not listening as hard
to
to every.
anything. So, you get to highlight the worst parts of it and just have them walk right into it because they're going to do one of two things. They're going to walk right into it and be exposed, or they're going to ignore it completely, which maybe is even better for my rebuttal, which is they can't just ignore the evidence. You can't, you already swore an oath that you can't ignore the evidence. So you have to do a harder job than the defense attorney just did for you, which should make you question some of the arguments that you heard from them. If they're not prepared to confront the evidence in the way that you swore an oath to, they may not be the person to trust when it comes to what that evidence means. But that's for you guys to decide.
I love it. And it goes back to something that you and I've talked about it. I think Rex Parris was the first person that ever heard say it. It's probably not the first person who ever said it in my presence, but the first time I really heard it. But it was really hitting on the concept of we're not there to beat the defense attorney. We're there to persuade the jury. And
Yeah.
so, I love, and I don't think of it as sandbagging at all. It's like, hey, I'm going to tell you about our case. I'm going to let you tell, they're going to tell you about their case. And then, I'll come back and we'll talk a little bit more together. Um, you just stay out of their way. And it's like,
Yeah. And it's
I'll tell you
also
what to
just
do.
objectively respectful. It's respectful of your opponent and their platform because I'm not going to trial on a case I think I'm going to lose. I'm not going to trial on a case that I don't know what I'm doing on. So, well, I really shouldn't be afraid of anything the defense is going to do this far into trial because they're limited to the evidence that was presented at trial. And if they want to go beyond the evidence, well, that's even better for me too, because then I get to stand up and say, look at the hypocrisy, right? Look, you get to judge us, our case versus their case. And our case relied on the evidence, and their case, in a lot of ways, misrepresented the evidence. And that's a kind of a crucial technical skill for rebuttal is we're not there to hammer the attorney, but the attorney is speaking on behalf of the defendant in closing. And if they misrepresent the evidence, it's not the attorney that did that, it's the defendant who did that. And that puts the accountability where it actually belongs. And it's consistent with how almost every judge in America wants you to behave in trial, which is don't talk about each other. Don't talk about Mr. So and so is a jerk or a liar. It is the defendant who put that position out there, not the lawyer, right? The lawyer doesn't give evidence and they can't really speak other than for their client. So when the attorney misrepresents evidence, it's Starbucks misrepresented the evidence. It's Chevron misrepresented the evidence. It's Ocean Villa Resort misrepresented the evidence to you.
Love that because it's not going to be that defense attorney's name on the verdict form.
No, it's not. And to be honest with you, he's doing his job or she's doing their job. And I was just watching Nick's damages rebuttal on Starbucks right before we logged on. And, he even did that. He turned to the guy, he goes, this guy's my friend. I don't feel good for him today because he had to play the hand that Starbucks put into his hand. And he's doing his job. He's a good man. But the arguments that Starbucks thrust upon this man to give to you are unfair and immoral. So I'm sorry for this man today in the job and being forced to do this thing on behalf of Boeing, Monsanto, Starbucks, whoever your big bad is.
I mean, and the best part about all of this, and this came up a lot, during this tort reform battle, it's like, guys, it's true. Like, we're not saying it just because it's a good argument. We're saying it because these things are objectively true. We are right. They are wrong. So let's not just be like a little bit right. Let's go ahead and pull the curtain back and show everyone the entire picture so that everyone can be just as horrified as we are from what
Yeah.
they deserve to know.
And that plays in great to rebuttal because in addition to knowing how you're going to get into it, right? We talked about a bunch of different mechanics on how you get into it. We're going to talk about how you get out of it. But what are you supposed to do in the middle? And in the middle, I think there's a couple key things that have to happen. Number one, you need to be a technician, right? You better have your white or your yellow notepad out, and you better be writing down quotes from the defendant that don't match the evidence exactly. And you better be ready to go grab that yellow pad and tell him, here's what he said. Here's what I heard. I wrote it down. You heard it too. If you heard something different, go with what you heard. But here's what I think all of us heard. And I repeat it. So let's talk about that. What does that mean? Let's dismantle that. And sometimes we can dismantle that with logic. Sometimes we can dismantle it with emotion or suspicion. And sometimes we dismantle it by just going back to the evidence and showing that this thing doesn't match this thing. But that's one of those things that you need to be quick about. That's one of the challenges of rebuttal that I think is rightfully scary, is holding them to account in real time. But that's just as important as getting in, with a technical device. Is what do you do when you're there, right? You had your lovely, device that you set up, you got into your rebuttal. Now they need meat. They need responsive arguments to the defense's arguments. And you better have a response to the defense's best argument and not only exploit their weakest argument, because and this is why it matches voir dire for me. It's like, I want those jurors to give me hell. You know what I mean? I want them to tell me the worst thing that I could possibly imagine about my case so that we can get it out there, we can discuss it, and they can go home for cause, they can rehabilitate themselves, or I can, exercise a peremptory in an intelligent way. It's really the same process in closing. Is you need to confront the defense's best argument as an opportunity, not something you should run from or be scared from. But this is an opportunity for me to display to you folks that I am not afraid of the nonsense that's happening over there. I'm not afraid of their evidence. I'm not afraid of their arguments. Let me show you why our side is at least a little bit more likely true than theirs is.
I love it. I love it. Brian, have you ever gotten into, I mean, something that stands out to me a lot is, the other side will get up and say what they want to say, put up whatever witness they want to put up, present whatever evidence they want to present. And it's like, it's all good and well, but it doesn't change the fact that, like, typically they did wrong. Someone got hurt real bad. And under the law, the innocent person who was harmed uh, is supposed to and shall receive fair and full
Yeah.
compensation and balancing for what's been taken from them. Um, in rebuttal, or there are times where you say, look, they just spent however long talking. But let's think about it. Nothing they said changes the fact that A, B, and C.
Yeah. Well, this is important, that our whole process is telling the truth. I don't think there's anybody that would listen to this podcast that would be the kind of lawyer to put up, you know, uh, evidence in their case in chief that they didn't believe was God's honest truth. I don't believe that we're talking to any attorneys like that. So assuming that's the case in rebuttal, one of the equally difficult things to do, being quick, being technical and all this stuff, is trusting your jury. So, maybe the biggest artistic choice you need to make in your rebuttal is how reserved or restrained you're going to be in some of your arguments. Because just like you want to leave those rhetorical questions for the jurors to be skeptical about during the defense, you want to leave them some room as you're walking down the trail with them as well. So you can be pretty clear where you're going, and then you can stop right before the end and say, and I think you should talk about that. And I think you should have a discussion about that. And I think you all should decide how you feel about that and how that issue is ultimately going to pan out. I've got my thoughts on him, but you're the jurors. So I'm going to leave it to you. But I trust that you're going to examine it closely and you're going to talk about it thoroughly and you're going to come to the right decision. You don't need to tell them every freaking answer. Do you know what I mean? The jurors are smarter than you think. And I have to remind myself of this all the time because, if you get seated in that box and you raise your hand and you stand up and you swear that oath, 9 out of 10 jurors find the experience really meaningful and they take it really seriously and they end up feeling really good about their service to the system and to their country by the end of it. So knowing that they're there in good faith, let's trust them. Let's trust them to figure out where you're going, but to also have the pride of getting there themselves. If you just look, everybody's dream is, I just want to tell them what to do, and I want that verdict to come back exactly like what I told them to do. I got very upset early in my career when they didn't just do what I told them to do. But that expecting them to just do what I say robs them of their experience of getting there. It robs them of the beauty of the jury system, which is collaboration and collective wisdom. I want them to have that journey. I want them to have that experience. I want them to have something unresolved that they feel it's their task to resolve. Without me being heavy-handed about it. Like I said, I'll guide them down the path, but at some point you have to say, and the rest of the path is for you to walk.
Excellent. When we get to the end of rebuttal, we've talked about how we introduce it. We've talked about the way we structure it, the meat in the middle, and when it comes to the end of rebuttal, what are some of what you've found to be best practices?
Yeah, you got to get out. You got to plan to get out, and you have to sit down on something powerful. So maybe let's work backwards from the end and kind of talk about how I think about building it. The last thing I want to say to the jurors is some combination of thank you and I trust you. So I know that that's going to be the thing I end on, and that's not a thing I would script because I want to say it as genuinely as I can. And honestly, after the extraordinary exercise of having to do rebuttal, I do feel it genuinely. So I just want to express that however the heck it comes out of my mouth is thank you, and we trust you to do the right thing. Working back from there, how do we create a position where that is going to land, both from me as the speaker, where I'm going to be authentic when I say that, but they're going to receive it in a way that is special. And you got to get some heft on your case, right? So this kind of comes back to, did you find the emotional core of your case, through exercises that you did along the way? Because this is a good place to talk about the emotional core of the case. So what is it about the case that a person might give a damn about? A lot of times, and you've seen this, Kenny, at Trial by Human, it's like, hey, what's your case about? On Tuesday, August 23rd at 3:52, a motorist was proceeding eastbound on a boulevard. It's like, I don't care about any of that. You know what I mean? So that's not your case. What is your case? Here's a guy who had just turned his life around and, maybe mended his relationship with his daughter, and they were really excited for this next phase. And all of a sudden the rug got swept out from underneath them. Just as a kind of a made up example, but there has to be stakes for plaintiff, right? Why do we care about this person? In America these days, it's getting pretty hard to make somebody care about somebody else. But there are some universal things that kind of get us. So if you can find that thing in your case, well, then the jury's gonna be like, well, at least I give a shit. You know what I mean? And sorry for cussing, but that's kind of the bare thing. Can you get the jurors to even give a shit in the first instance about anything you're talking about? And that's where you need to find the emotional core, and that's where there needs to be heft on it. They need to feel that there are stakes for the plaintiff, important stakes, and then you need to put the emotional heft onto the jurors and in their journey and their experience. So once you've got them like, hey, there's something here that we should care about, what the hell are we going to do about it now? Right? Like, how are you going to motivate them to act in a way that is exciting for them and fulfilling for them and makes them feel that they've done something important? Because it is easy for a juror to be like, I got picked for a freaking auto case. Some guy got rear-ended and now his neck hurts. I'm so annoyed that this is the world that I live in. If you get to the end and your juror feels that way, you have failed in some way. And in rebuttal, if you picked a good jury, you tried a good case, now's the chance where you can put some meat on the bone for that juror. Because we just talked about, they enjoy the process. And, I've seen wild things happen. I've seen a case where I've just absolutely dismantled the defense attorney. And I'm like, oh my God, this verdict's going to be amazing. And they come back and the jury's like, we felt really bad for the defendant because their attorney sucked. And we figured out some better arguments. And we made them on behalf of the defendant because we felt that the defendant was entitled to better arguments than their attorney made. And I was like, well, I didn't know that. So I didn't get a chance to rebut them. You know what I mean? So a jury will do a lot, right? If you give them a lot to do, they will do a lot. They will dig in and they will do hard work. So give them hard work to do. And, there's some, how do you put heft onto that? I like to talk about democracy, right? Because whoever you like, whatever party you have, you like democracy. You like the fact that we get to vote and your voice matters. And every side has frustrations with how we are not a true direct democracy, right? We are a democratic republic and we choose our president through the electoral college. None of that's direct democracy, but Americans believe that direct democracy is the best. So whatever political grudges they're feeling, you don't need to talk about. But I like to say, in this courtroom, we engage in direct democracy, and every vote counts. And that's it. Whoever you are upset with in the political spectrum, whatever you're mad about, whoever you're gunning for, we actually all agree on that. Like, I want my vote to count. I want it to matter. I'm a California voter. It doesn't matter what I do. We are such a monolithic state when it comes to our voting block. My vote does not really matter. It doesn't. And that's a dangerous thing to think, but there's some truth to it. Tell you what, your vote matters. If you're 9 of 12 jurors or 6 of 8 jurors, wow, does your vote matter a lot? And you have the ability right here today in this courtroom to change the world. You might only change my client's life, in which case you've changed the world in an important and meaningful way that you should be proud of. You may have changed the behavior of a corporation that's going to think twice next time they're dealing with a child in a pool, toxic chemicals under a house, Starbucks drink that was, carelessly left unprotected. You might also change the world. You might make the world safer. You might let other corporations know that we still exist. You might teach a corporation that under our Constitution and in this courtroom, you are no bigger than the plaintiff whose life you interrupted. You are not a $1 billion company in this courtroom. You're a party to this lawsuit, and you have no more or less rights than my client does. So we meet here on an equal footing, and your vote counts. So just from kind of what people would say is flag waving, there's a lot there. There's a lot there for the jurors to think about, to put themselves into context. Why did I just spend my last 8 days here? And what am I going to feel about this process when I go home?
Brian, let me ask you this, and it's probably something you've thought about because you're a thinker. But when you were talking about democracy and then you mentioned democratic republic, I got to thinking about the the direct democracy piece, which and what you laid out was super powerful. Um, have you ever also talked about with jurors the fact of who they represent for all these times
Oh,
where someone else
yeah.
represented them and they've we could talk about that for hours, ladies and gentlemen. But here's the difference. Now you get to not only be the voter, but also the ones who are representing your community.
Yeah, absolutely. And some cases lend themselves a lot more to that. So, in the Chevron case that we had where there was toxic crap underneath this guy's house and it gave him, cancer and ruined his life. This is a community that, number one, had already been impacted by 100 years of oil and gas exploration in California. So they had context and it was real for them. Some of their personal communities had literally been rebuilt. I mean, like Avila Beach in the central coast of California was so decimated by oil contamination that they literally had to like pick up the historical buildings, move them to the side, and like take out 40 feet of soil and replace it. And then, they rebuilt a whole damn town. People remember this. Do you know what I mean? People know what's been happening in their community. So we were in context, right? We were an ongoing, you know, uh, desecration of the land without accountability. So that means a lot, right? They were representing those jurors. They were representing not only themselves. Um, they were not only there to put it right for our particular client who had been damaged so badly, but they got to speak to the historical context of how we feel about the oil and gas companies doing this to us in our homes. And that was really powerful. And, in that case, it lent itself really well to a slightly different, emotional heft for the jurors because the defense brought in all these, canned experts that testify for oil and gas all the time. And part of the themes of my crosses were you understand your testimony is public record, right? I know everything you've said in the past because it's the public record. And I kept saying public record, public record. And I was like, I got it right here. You don't remember it, but I'll read it to you because it's part of the public record and it lives forever. So that kind of bug was in their ear. And when we got to rebuttal, the heft I put on it was, what you guys are doing is writing the history book, because you heard that everything that happens is part of the public record, including your verdict. You your voice will be entered into the literal history books of not only my client, but this town and this state and this industry. And you will write down for everyone to see forever whether or not these communities accept this kind of treatment. And you will set the precedent for history into the future. And that's a big ask, and that's a lot that's on your shoulders. And you're going to have to take your time doing that, and you're going to have to realize the importance of it. And you're going to have to come together and decide, for history's sake, what are the standards in this community. You get to set them, and they will live forever.
And true. Again, when we go right back to it, it's like, man, one of the reasons this is so powerful is because it's true. Like it's
This is
all
true.
true.
Yeah. And then, for even, lower stakes, right? Not every case has a 100-year history of raping the land with a big bad oil company, right? Some cases are just this guy versus that guy, or this gal versus that gal. The stakes there don't have the same kind of historical context. But when it comes to community standards, the same argument applies, which is, we're going to write down your verdict. And anyone that wants to know whether or not this kind of behavior is okay around here, they can ask you. They can go look in the book where you wrote it down, and they'll know that's not okay around here. We don't think it's okay to mow down a homeless person because they weren't in a crosswalk. That's either okay or it's not, because that's their defense, right? This is a homeless person with mental diseases and they weren't in a crosswalk. So what did you want me to do? Well, I wanted you to not mow them down just because they were 10 feet out of place. And I just think that's, maybe we can all agree on that.
Yeah, we've got a good pedestrian statute here, but it doesn't. It's not like reading the statute. That's more of the, like you said, the the meat and potatoes, not the emotional heft. I've never seen
Yeah.
a heft come from, well, the statute says. Hey, Brian,
Yeah.
with the last few minutes we have left, anything else in terms of exit strategy, the end of rebuttal? This has been excellent, man.
I mean, you need to look them in the eye. There's been a few times in my career where a defense attorney has stood up and said, Mr. Ward just said a number that's crazy. And if I'm being honest, I don't think he believed it when he said it to you, but you should all figure that out. And I was like, oh crap. Because I've done that earlier in my career. I've done that. I've given a number that I was afraid of, that I didn't believe in, and it was all over me. So in terms of getting out a rebuttal, the best thing you can do is be honest with yourself, is look them in the eye, because, when that happened to me, I'm gonna be honest, I had it coming. I had it coming. I mean, he busted me, man. He had way more experience than me at that point, and he saw it just as clearly as the jury did, and he busted me on it. I was like, well, that's never going to happen again. Except it keeps happening again. Except now it's not true. I didn't deserve it. Now they did it to Nick in Starbucks. They accused him of not believing his number. He had to get up and rebuttal and be like, look, maybe some attorneys do that, but look at me, and I'm telling you I don't. And I'm going to make eye contact with you. I'm going to make eye contact with you, and I'll do this all day, as long as y'all want to like look into my eyes and read my soul. Here I am, wide open book for you. I mean, every last damn word I say. And as you get to the end of your rebuttal, I think everyone wants to wave the flag and pound on the desk. I think it's the opposite. I think you want to bring it down. I want to slow down completely. I want to leave a lot of silence. I even want to be a little bit contemplative, because now I'm modeling for them the sanctity of what's about to happen in the jury room. I don't, because you can pound on the desk and, spit fire, but then they're going to stand up and slowly walk into the room, and they're going to sit down, and they're going to be like, what do we do now? And here's this packet of crap that we need to go through. And I guess we're supposed to elect a leader. And it's like, well, that doesn't match. That's a mundane task compared to your fire and fury. That's just emotionally not consistent. So I like to bring it down and retreat a little bit in terms of my presence, quieter, slower, more contemplative, and a lot more eye contact. I will ground myself in the middle of the jury, right? This is when you have to stop wandering around. You need to plant your feet. You need to square up. You need to have, your hands in one of these neutral positions that leaves you comfortable and looks like you're trustworthy. And you need to look them dead in their eyes, and you need to tell them the hardest thing that you've ever said in your life, which is it really is worth every penny of 50 million or whatever you believe the number to be. You can be as clever as you want, and Lord knows I think I'm clever. You can be as quick as you want, and Lord knows I think I'm quick. But if you can't slow down and just be there honestly with them in that last moment, then your tricks weren't worth anything. So all of that is to have the technical acumen to cash in on your personal credibility in that last moment. And you have to just stand there and withstand the uncomfort of the silence, to withstand them staring at you, because they are staring at you. And some of them are already even contemplating what they're going to do. And maybe what they need is just a minute to sit and think before they stand up and have to look at packets and they get handed candy or something. Maybe they want a moment to reflect for themselves. So I like to give that space for them as well at the end. And then again, the last thing I tell them is usually that I'm humbled, that I was allowed to do this job in front of them, that I'm extremely thankful for their care and attention, and that I trust them completely.
I mean, a lot of what you've described, I think of this, you have handed them, if you want to call it the ball, the torch, the child, whatever it is you have placed, in essence, this responsibility, this honor in their hands, and taking a moment to actually do it versus, like you said, the big fiery high, to all of a sudden, there's no music and they're just credits rolling.
Yeah. Well, it's like Brandt said in The Big Lebowski: "Her life is in your hands, dude.
We
Her
can't
life
do
is in
better.
your hands."
We can't do better than the Big Lebowski. Man, it's been so much fun having you on. Brian, for folks who want to get in touch with you, how do they do that?
Hit me up. You can email me, Brian Ward, BrianWard, at TL4J.com. That stands for Trial Lawyers for, the number 4, Justice. You can text me or hit me on my cell. That's 818-259-0988. Or you can come track us down at a Trial by Human event, which is maybe the best way to hang out of all. And while we're talking about that, Kenny,
Dun,
you
da,
want to
da,
let the folks
da.
know what's
September
happening?
26th. September 26th, live in Charleston,
What are we
South
doing?
Carolina. We're doing Trial by Human.
That's right, folks. Trial by Humans come to Charleston, September 26th. It'll be a one-day event. Please mark your calendars and come on out, and let's talk cases and strategies, and let's enjoy each other's company.
And because it's my podcast, I can say this. It's going to be fucking amazing. It's going to be
You
really
heard it here first, folks.
great. Thank you.
Thank you, Kenny. A pleasure.
Once more, our guest today has been Brian Ward. Thank you so much for listening, and we look forward to doing it again soon. And we will see you in Charleston, Trial by Human, September 26th. Thanks so much.